Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the questionnaire chat box and they'll be brought up at the end. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Good morning, everyone. Welcome to The New Normal, your go-to source for insightful discussions on the gaming industry and critical issues affecting Native American tribes across the United States. I'm Victor Rocha. I'm the conference chairman of the Indian Gaming Association. My co-host is Jason Giles. He's the associate director of the Indian Gaming Association. So welcome. Our guests today are good friends Judy Shapiro from Shapiro Law and Scott Crow. Scott, are you with the Tribal Advocacy Group? I have
That's the firm is Crow Law Office Tribal Advocacy Group. Yeah.
Crap. All right. I'm going to make sure I get those notes. Welcome, everyone. Today, we're discussing the recent announcement from the Department of Interior regarding updated regs for Class 2 Indian Gaming Compact. Jason, what does this mean? Is this a big deal?
Hey, well, we've got two esteemed lawyers with us, actual litigators. Unlike my sorry litigation career of 4 years, all in Hawaii, but probably a little more fun than your guys's. So going to the little small Kauai courthouse with.
Are we talking about that birth certificate thing?
Exactly.
In Hawaii, is that what we're talking about?
It over there, but in an old dusty box. But Victor, the gaming compact regs issued as a final rule last week. Scott and Judy have been instrumental, whether they know it or not. Of course, Scott knows it, and it says it in the preamble of these regulations. And talking to Brian Newland and Paula Hart at the CNIGA conference last week, they acknowledge that our hardworking Indian attorneys that have, against oftentimes advice of organizations, other tribes, other naysayers, take the deal with the governor, take what the governor's got on the table. That's the best you're going to get. Well, it isn't. And that IGRA wasn't designed to take the best you're going to get. And we have two attorneys that have lived this since the Seminole decision, when one of the main legs of tribal state fairness in contracting and compacting was kicked out from underneath tribes by the Supreme Court's decision. So since then, tribes have been at a significant disadvantage when negotiating with state governments over tribal state gaming compacts. And, an attorney like Scott Crow didn't take no for an answer. And if a bad deal is a bad deal, you've got to go to court and get it declared a bad deal, or petition the Interior to tell them not to approve it because of these factors. And some of those, and it's in the preamble, are really the executive summary of this. It's 212 pages, not the executive summary, but the executive summary does a really good job of explaining how from 2008 to today, we got to this point where we can now have standards that the Interior can use to evaluate state tribal gaming compacts, and whether something's a tax, whether something's an undue burden, whether it's for the benefit of the tribe. So with that, let's Scott, since you were at CNIGA yourself last week, I don't know if you got a chance to talk with any Interior folks, but well, go ahead, Victor.
I'm trying to find the regs so I can I'll send them to Lisa so she can post them if everybody wants to see them.
Oh my God, it's massive. Okay.
Yeah, I got it. Hang on one second. Okay.
Yeah, it's a long document.
Go ahead, finish the conversation. I'll be working on it.
But Scott, let me just kick it open to you first. Talk about your strategy, really, when especially it starts with Schwarzenegger, maybe even before that. Some of these governors, they just did not want to deal, and they used that Seminole decision as a sword to sort of bat tribes down. And we never thought that we'd be in a position to, absent legislative fix, to sort of level the playing field a little. And then Judy, we'll get to you because Class 2 has certainly helped as well. But go ahead, Scott.
Well, yeah, and thank you for that introduction, because I think that to really understand the significance of these regulations, it has to be looked at in the historical context. Congress clearly envisioned that the department would be basically a filter that would prevent bad deals from getting approved. But ever since the seminal decision in 1996, when the Supreme Court said Congress can't abrogate state 11th Amendment immunity, which allowed states to assert 11th Amendment immunity in any lawsuit brought by a tribe under IGRA, it's totally skewed the negotiation leverage of tribes at the table, and also compromised the department's ability to approve the compacts, because they would be faced with this odd circumstance where a tribe and a state would come into the department with a deal that frankly didn't pass muster under the scrutiny that the department was supposed to give, but put them in a Hobson's choice, because by disapproving the compact, oftentimes it could result in the tribe remaining on the outside looking in. Over the years, frankly, there are probably dozens of examples of compacts that should have been disapproved. One of the things I like about this rule is codifying the process for these deemed approval letters, which is basically explains that, we've got concerns over these compacts, but we're going to let them go into effect, but only to the extent otherwise consistent with IGRA and federal law. The Schwarzenegger decision and all these decisions that are coming out of California, that's really the only post-seminal body of federal case law in terms of what does constitute good faith and bad faith. There's a few tribes that got through before, the 11th Amendment raised its head and started knocking out these IGRA lawsuits. Judy can speak to, the Mashantucket Pequot situation and Lac du Flambeau. But ever since Seminole, it's only been limited in California. And that's because back in 1997, when the tribes realized that they had the political clout to get initiatives through, they got Proposition 5 through. Now, that was a statutory initiative that ultimately had to be superseded by Prop 1A in 1999, which was the constitutional amendment. But as soon as the ink was dry on Prop 5, HERE filed a lawsuit in the California Supreme Court, and they struck down the Prop 5 in its entirety, with one exception, and that we were smart enough to write into the initiative at the time that the state of California waives its 11th Amendment immunity in any action brought by a tribe pursuant to IGRA. And that's still on the books. The Supreme Court struck down every other word of Proposition 5 except for that one sentence. And that is enabled the Rincon Band and the Schwarzenegger litigation that reflected in the rules in terms of what constitutes legitimate revenue sharing. And then more recently, the Chicken Ranch case and all the different California cases that really, I think, is the definitive case on defining where you draw the line between what's directly related to the regulation of gaming, which may be in a compact, and what's not. The rule reflects that. But Judy lived some of that history as well in terms of how we got into the situation. So I think I'll throw it over to Judy.
And Scott, thanks for clarifying. I mean, I just learned something. I just thought it was the California tribal nations, recalcitrant attitude that was the reason that they were always running the court to fight this. I had no idea was that language in the Prop 5 that allowed them to take the state to court. And because you saw like Alabama, there's numerous other states that were, far worse than California, and you didn't get that pushback from the tribes there, but they had no recourse. That's why. So,
right.
So was really smart. And you know, Judy, well, I'm interested here, Judy. So Mashantucket, because you know, they notoriously had a hard time with their governor. And
Well, yes and no. Okay, so let's go back a little
Yeah.
into history. And I gotta say, this is the not so new normal because,
okay.
you know, substantially what this stuff does is codify what the practice has been. And if you have as Scott points out, if you have a state that's recalcitrant, California is the only place where you can really challenge it outside of procedures, but that's a side question. So back in the bad old days, Mashantucket did a good faith compact lawsuit in 1990-ish, early. But it was not a hostile lawsuit. It was, okay, you sue us, the state says, and we will, we will respond and we'll do the whole compact, the procedures process as set forth in the statute. Here's our offer, here's your offer. And Interior, the secretary will pick one. That's how it's supposed to work. This is before the 11th Amendment came in. And they had a compact, which was approved by operation of the secretary's approval, not a compact, procedures. And they later amended it with a side agreement that gave them slots. And the slots gave them 100% exclusivity within Connecticut in return for a gargantuan share of revenue. They did not submit that. They did not submit that because the conventional wisdom that would be not approvable as a tax, which is illegal under IGRA. And so they're going along. They build what was, I think, then the biggest casino in the world, giving millions of dollars to the state of Connecticut every year under a document that nobody had looked at. 1994, and this is where I came in on this one, Mohegan is recognized. And in the 60 days after the recognition became effective in March of 1994, we negotiated every agreement that was necessary to have with the state of Connecticut before the recognition was final in order to avert a challenge to that recognition. And we negotiated a compact. And we negotiated a compact. We had a compact signed with the understanding that Pequot would not challenge it and would step back from its 100% exclusivity to allow Mohegan to share that exclusivity, so long as the Mohegan Compact incorporated every word of the Pequot procedures and the side agreement that allowed for revenue sharing in every aspect. And I will tell you that the way that worked is we photocopied it and we used whiteout and changed the word Mashantucket Pequot to Mohegan throughout and submitted it. And then we swallowed hard because the Interior was going to look at that and it had never approved a compact with revenue sharing. And this was the deal. And that is really where the substantial, meaningful concessions and substantial economic benefits principle arose. We argued the value to the tribe. The state said this is worth it for us. We argued the value to the tribe. And most importantly, Pequot did not object, so that theirs did not go up in flames, but they had the benefit afterwards of having that precedent set so that their side agreement was not going to be challenged. So that was in 1994. All of that was happening. Seminole comes by and goes to the Supreme Court, and the decision comes out in 1996. And all of a sudden, no cases can be brought. 0 cases can be brought. And we go to the secretary and work with the secretary and the Department of Interior to establish regulations for procedures. The procedures are adopted, Seminole tribe submits them, and it's years before that resolves. It's years, because there really is no enforcement. There's nothing that says this has to happen in a certain time or you're in bad faith. There's nothing that says the tribes can go to court if nothing happens. There's nothing. So the new normal, except in California, is the same old normal, because the elements that are acceptable for compacts are the same as they were, except for most of it was not codified. That's the good thing, is there's sort of a secret practice group of those of us who have done it that say, well, what you need is this, what you need is that, this is what you can have, this is what you can't have. And mostly only in the occasions that the Interior Department has declined to deem approve something, and it basically says, no, that's too far. The example being the first Mashpee compact as submitted, that generated either an 11 or 12-page letter that said, here's what's wrong with this, and we just can't approve it, which resulted in Mashpee going back to the table and negotiating a much better compact. But some of the things that were wrong in the Mashpee letter have been wrong in other compacts that were affirmatively approved by the department. And the question Scott and I think, want to ask the department is, so do you mean it or do you mean it? You know, are you going to keep on approving? Are you going to deem approve things? Are you going to affirmatively approve things that violate your own rules about what's acceptable within the compact process?
Well, let me ask then the political question. Was there a difference in what administration was it reviewing these?
Absolutely.
Okay.
Oh, yeah. Major differences from administration to administration. I have to give hats off, for the lawyers that are on the call. There's a law review article that Kevin Washburn wrote after he left his ASIA position. It's in the Iowa Law Journal, where he talks about the curious creature of the deemed approved compact. And he pretty much concedes that you've got this horrible record that shifts from administration to administration, where you have a lot of these compacts that were affirmatively approved, even though they violate IGRA. And then you have really starting with his predecessor, Larry Echohawk, and the Clinton administration, you had the practice of these deemed approved letters. Very few people know that not a single compact negotiated by Jerry Brown with the California tribes was affirmatively approved. They were all deemed approved. Not a single compact negotiated by Susan Martinez in New Mexico was affirmatively approved. They're all deemed approved. And they started this body of almost similar to administrative case law, these letters, starting to explain and create a record so that you could have some consistency. Brian Newland was involved in that, when he was, in the ASIA office. And now that he's assistant secretary, these rules, are taking it a step forward to try to create some codification of consistency of where you draw the line. Judy says, the new normal is the same old normal. And in some respects, I think that's true. I look at more as these rules, provide us a glass that's half full, because it does provide clarity now to where if you're a tribe outside of California and you're at the negotiation table, you can point the state to the line items in the rule saying, look, you've crossed the line, especially as it relates to revenue sharing and items not directly related to the regulation of gaming. But it's only half full because Judy mentioned other regulations, and I think that does need to be part of a continuing dialogue, with the department, with the, there's 25 CFR Part 291, and that is, was designed to provide an administrative fix for tribes outside of California that are confronted by 11th Amendment immunity. And you have case law in both the Ninth Circuit and the 11th Circuit, before those regulations were promulgated, that basically said, department, you need to fix this problem because IGRA is broken and you should do it through rulemaking. And so they promulgated the rule. But the Fifth and 10th Circuits have said that the rule as it's currently written violates IGRA and federal law. So we still, in order for the glass to be fully full, we need to come up with a process that provides tribes an effective remedy when they're confronted by state 11th Amendment immunity.
Well, so some of these this reg will help alleviate a lot of those issues you have both faced in the past, or do you still foresee some of the problems, moving forward, given that the playing field still isn't entirely fair, is what I'm getting at.
The playing field is what it is. What this does is that if the parties are, arguably in good faith, you can point, as Scott says, you can point to it and say, look, we can't do that. We're wasting our time. You can't do that. And that's the same thing that happened after the Mashpee denial letter, that when the parties went back to the table, it was clear what things could not be negotiated because the Assistant Secretary had told us. There are some things that you just can't do. And if that's the best you can do, well, then we're going for our compact lawsuit now. We're going to have you're going to either will or will not assert the 11th Amendment. We'll be in the procedures process, but we're not going to waste any more time dickering with you.
Right.
And when we go to the procedures process, then there are rules that say what was in bad faith about it. That is very helpful.
Mm-hmm.
It's no longer going to be the secret knowledge. It's going to be the fact that there are rules that say they made these demands violate the IGRA, let's go from there.
Mm-hmm. You brought up Susan Martinez, Scott, and their fight with Powake up there got really nasty to the point where they were threatening the vendors to the casino.
That's right.
And I don't know if there's anything in these regs that can start to, when a state starts to take underhanded retaliatory action, maybe that's part of a bad faith case, but again, you face some hurdles just getting into court. Is that correct?
Well, one of the things that I find interesting about these regulations, is the language regarding the deemed approval. And I should qualify that, I did represent Powake in that litigation. I'm not currently representing Powake. So my suggestion about what this rule might do for them, does not necessarily reflect what their view may or may not be. But Powake, in sharp contrast to, I represented Rincon in the Rincon-Schwarzenegger litigation. And there, because we didn't have the problem of 11th Amendment immunity, we were able to take what are clearly illegal demands of state taxation of gaming revenue, establish a bad faith case, and get the court to agree, which resulted in the secretarial procedures that govern Rincon to this day, where both the Ninth Circuit and even the U.S. Department of Justice in their amicus brief in opposition to California's cert petition in Rincon, articulated that meaningful concession. You must have a meaningful concession to justify the revenue sharing that has commensurate value to what you're extracting from the tribes. That really came out of that original Mohegan compact approval. The underlying facts between Powake and Rincon were actually quite similar, but Powake, sued the state. The state asserts 11th Amendment immunity. They go to the Department of Interior under Part 291. The Interior reviews and is ready to approve the procedures under 291, informs the state that they're going to do it. The state turns around and files suit against the United States for arguing that the regulations were illegal, and while that litigation was ongoing, the compacts expired, or Powake's compact expired, and our trustees with the United States, the Department of Justice, and the U.S. Attorney's Office, and NIGC, all agreed in writing, to not take enforcement action against Powake, and that infuriated Susan Martinez, and she turned around and started issuing fines against all the major vendors that that implicated their licenses, not just in New Mexico, but everywhere, and that ultimately resulted in Powake having to capitulate, sign the illegal compact, which was deemed approved, as was every Martinez Compact. Well, now that we have this new rule codifying the deemed approval process, if you look in the comments, it's kind of interesting because a lot of commentators, I was, probably one of them, said, go that extra step. Say that if you have a deemed approved compact, then you can take action on it in terms of severing out and rendering unenforceable those provisions that violate IGRA or otherwise inconsistent with federal law. They declined to do that. They said, we're not taking a position on whether you can or cannot. There was a lawsuit filed last fall before the rules came out, but timely in every respect by the Buena Vista Band. It's not a typical California bad faith lawsuit. They signed a compact in 2016. It was deemed approved by the Department of Interior, and now they're suing the state, seeking a ruling that says every provision that, basically using the Chicken Ranch case and now these rules as a guiding force, every provision that is inconsistent with these rules, we deem unenforceable and severable. And that's an important case to watch because it's the first case that I'm aware of. I believe that these rules would enable Pewaukee, and not just Pewaukee, but all the New Mexico tribes, to take the same route. To say, hey, we didn't sign these compacts because they were negotiated in good faith. We signed them because they were the best that we could get under the circumstances. And since they were deemed approved, and the revenue sharing provisions are an illegal taxation of tribal gaming revenue, how that plays out, is going to be interesting. Where if you just unilaterally make the determination that they're severable and see, if the state files an action against the tribe, well, then you don't have an 11th Amendment problem. Or you could do what Buena Vista did, is sue the state. But there, that's California, where the state can't throw up the 11th Amendment as a defense. But I think one of the interesting things going forward will be, whether these deemed approved compacts give the tribes leverage to force those states to bring non-compliant compacts into compliance.
Yeah, as a layman, and I know you guys hate hypotheticals, but I have a hypothetical. What does this mean for Oklahoma tribes? Does this give them a little more ammunition in their pocket?
So this is part of where I wanted to go.
Okay.
Which is the regs say that they don't apply to existing compacts. They don't apply to compacts that have already been submitted. And they don't apply to compact extensions. And it's silent, but in a compact renewal, if you're going to submit a compact that's a renewal of an existing compact, and that prior compact was approved, but you're submitting it as a new compact, then the things that were wrong with it before remain wrong with it. And I think that at that point, tribes have an ability to raise an issue that they couldn't on that hoary old compact that was deemed approved. Scott, do you agree on that?
I do agree with that. It may be we're in an odd situation where the tribes with affirmatively approved compacts have the least amount of leverage because of the deemed approved language. But I think that the fact that a bad faith compact was approved in the past doesn't entitle the state to continue to impose those terms
that's what I mean.
in a new compact. The Indian Gaming Regulatory Act requires the state to negotiate in good faith, and the fact that they got away with something before doesn't entitle them to get away with it again.
And those come up in a number of areas because The department has chosen over the years, it's vacillated between, well, we're not going to say, we're just going to let the time run out and deem it approved, to affirmatively approving compacts that just should never have been approved.
Right.
And if you want to transition a little to the class 2 thing, the examples, one was affirmatively disapproved in the first Mashpee compact was the attempt to regulate class 2 gaming. What is in the new regulations is that you can't regulate class 2 gaming. Well, that means you can't regulate class 2 gaming. So what do you do with compacts in Arizona that say you can have this many machines and your class 2 machines count towards that? I think Scott and I had some really angry phone calls when those came out because that's absurd. That class 2 gaming machines are totally outside the scope of the subject matter of a class 3 gaming compact. And any attempt to regulate numbers, including class 2 gaming, is the same thing as saying you can only have 300 machines, but no Coke, Pepsi. You know, it's irrelevant.
Yeah, I thought that was settled a long time ago. You know, it seems like that was settled case law with the class 2 and counting them. I know, again, from my layman's mind, I can think of a handful of examples. But go ahead, Jason. I'm digressing, I'm sure.
That's a case in point, but that's a case in point, Victor, is even though it's clear that you can't regulate class 2 gaming, when the last round of Arizona compacts were renewed, that class 2 language didn't change, not one iota. And that, that was just a couple of years ago when they were all renewed to allow for on Indian land sports wagering.
Mm-hmm.
Well,
and so it's the same thing as how much do you want this and what will you give up for it?
And Scott brought up the comments and the commentators, of which he was one. But, Victor, our friends in the commercial gaming were commentators too on these regulations. I don't know that they specifically commented on the state tribal gaming compact regs, that group, Victor, I always forget their name.
IDEA.
IDEA Tech, yeah. But clearly, if you're out there, a sports betting company, and you just want to run roughshod over the tribes in a state, you don't want them to have more leverage in negotiating a tribal state compact. But that said, Judy, I mean, does this at least help the balance a little? I mean, you said maybe not, but I mean, in Oklahoma, break it down. I mean, that's your answer was, a kind of probabilities. And if we just stick with, if you're a new tribe, your compact expired, you're going to renegotiate a brand new one. This has got to be a net positive, right? And it's got to be letting the commercial gaming know too, tribes are in control of their destiny on their reservations and with the state they're negotiating with. For commercial gaming to come in, and what they've done in the past in California and wherever else, they're trying to just run roughshod. Even in Arizona, it's not, I think the tribes may have some buyer's remorse there about what they negotiated with regards to sports betting. But maybe it was because, look, we didn't have much recourse when we were dealing with the governor. But now tribes may, right? Can we state that definitively, Judy, or no?
I don't think so. I mean, in California, tribes have the 11th Amendment waiver, and they have really, really significant and well-funded political clout. And that combination allows defeating a lot of the commercial gaming interests in a different way. If I'm in Oklahoma, and I don't presently represent any gaming interest in Oklahoma, but let's say I'm looking at the existing compact, and I'm gnashing my teeth about the fact that the definition of compact game in Oklahoma includes games that are really class 2 games. But the tribes, in their extreme desire for a compact and some security and some stability, said, okay, fine, we will deem these to be compact games and we will pay you a revenue share on it. And are they going to be able to walk that back in absence of a good 11th Amendment breach ability? That, you can point to it and you can say, this is wrong, and the governor can say, do you want a compact or you don't want a compact? And I don't think the balance of power at this point shifts. It can get, the discussion can be louder and it can be more pointed if people want to do it. Or people say status quo is making us money. Maybe we'll just go ahead and sign again.
Yeah. I don't know if I disagree entirely with that. I do think that this rule significantly moves the needle in giving leverage to those tribes in states outside of California to basically more clearly identify that where the state is overreaching. Now, if a state says I don't care, and I've certainly run into that, then you're no better off until we get Part 291 fixed, or you use Part 291 outside of the Fifth and Tenth Circuits. The important part about the sports wagering language that I think is very significant is that it does clearly instruct what a willing state and a willing tribe as to how they can get the tribe to be able to offer mobile gaming under IGRA with all of its protections that including NIGC oversight, the sole proprietary interest rule, the primary beneficiary rule, to where my disappointment in those state law models out there like Arizona and Michigan, to where the statewide mobile gaming element isn't under IGRA at all. It's under state law, subject to state taxation without IGRA's protections, so that companies like DraftKings and FanDuel can come in and grab all of the revenue. So the new rule, which basically tracks what the DC Circuit said in the West Flagler appeal, I think is a huge benefit. But it doesn't provide a clear answer to what a tribe does in a state that is basically, lock the tribes out, authorize statewide mobile gaming, but not for tribes. And I remember, we've had some previous discussions, in other contexts where, I brought up the example of Oregon, but I think it does serve as a great point, and it'll be interesting to see whether this new rule will be accepted in good faith by the new governor there, because Kate Brown, the old governor, took the position that even if she wanted to, she couldn't compact with tribes for statewide mobile sports wagering, where in Oregon, the sole provider of statewide mobile sports wagering is the Oregon Lottery, in an agreement with DraftKings, where the current agreement gives DraftKings 49% of the revenue that is raised, and has in their contract a provision that says if the state compacts with a single tribe for a statewide mobile gaming app, then DraftKings share goes from 49% to 85%. And there's 9 gaming tribes in Oregon, and if they compacted with as many as 5 of them, then that number goes up to 95%. So, and we found that out after the fact. We asked for that information, they refused to provide it, and we later got it through a FOIA request. But they actually wrote into a contract a commercial disincentive for the state to be able to negotiate with the Oregon tribes in good faith.
Scott, did you see their 2023 numbers in Oregon?
Oh, they're shooting off the roof.
Yeah.
They
well, no wonder DraftKings is now turning a profit. It's like, well, you get a deal like that, and the lottery got hosed. They didn't get, They got a fraction of the total bet.
Hey guys, I have a question. So
Yeah, we got a couple questions here with
how does this, it seems like a big part of this thing, as I read this, is Flagler, the West Flagler thing seems to be a big component. From what I see, the industry is freaked out because I think a lot of the seminal decisions, the seminal stuff is baked in here, and that's what they're freaked out about. The fact that the server is on the reservation, and it seems like it allows the tribes to participate in mobile and online gaming if it's legal in the state. You know, everything about the Seminole case was, you know, an agreement with the governor, agreement with the Secretary of Interior. It was passed. They didn't like it. They challenged it, went to the Supreme Court. Basically, it stood well for that decision, saying that the Secretary of Interior can make those decisions. What does this mean going forward? Because I see an attempt by the industry, I mean the sports betting industry, at getting West Flagler, this attempt by a company out of Florida to make that, to annul it or change it or whatever. You know, how is that going to affect it going forward? Or what does this mean for the rest of the tribes?
I wouldn't be overly concerned with that challenge. This rule makes it clear, is consistent with the DC Circuit and West Flagler, and even if the Supreme Court were to overturn it, and that's everyone that's opined on it, even the ones that usually are anti-tribal, don't believe that that's likely. That case isn't over. The petition for cert was just filed on the 8th of February, and so we should know whether the Supreme Court's going to hear that case in the next couple of months. But the state court action, is an action under state law where there's a provision called Proposition 3. That on one side of it, it says any expansion of gaming needs to be approved by a supermajority of the voters. And then on the other side, it says, but that exempts compacting authorized under a compact. And so the argument in the state court case is that it violated Proposition 3. I think the tribe still has the better argument in that case. It's a court loaded with DeSantis appointees, and DeSantis is the named defendant in that case. But even if they were to overturn it, the result would be that Florida and the Seminole tribe would have to take that measure to the voters in a statewide proposition. And when you're offering the state more than $500 million a year in revenue, it's difficult for me to think that they wouldn't approve it if they had to go that route. But that wouldn't change what the DC Circuit said, which is reflected in this rule. I think the major reason that the operators are so upset with that, is because the IGRA provisions that come along with sports wagering under IGRA, where a minimum of 60% of the revenue must flow to the tribe in order to be consistent with IGRA, and they've been able to use their leverage outside of Indian country to where they're pulling down deals that are 95.5 or 97.3, nothing like 60-40. Frankly, I relate what they've been able to do with tribes operating under the state law models, is the same thing that these fly-by-night internet lending companies have been able to do, where they run a tribe, say, we're going to give you, a pittance of of the revenue that's being earned. You go sit on the sideline over there and we'll do everything. I think that's what they want to do. And I think that's why they're so upset with the Seminole model and the codification of that model in the rule.
Judy, anything? We got a couple
I'm
questions.
probably gonna get some hate mail for that, but I think that's the
No,
reality.
Scott, we're you know, we've seen those deals. I mean, you know, and well, let's contrast that with some of the more positive ones we've seen where IGT went to Mississippi Choctaw, built their sports book out, and then just turned it over to them recently, and now the tribe is running it themselves, and conversely taking the risks themselves. I mean, that's how they sell these tribes: is we'll do the model you just described, but we have all the risk. But you know, how much is their risk when they've got, you know, access to all these other markets? I mean, they're spreading that risk around, and it's baked into their calculations, and they're taking home a pretty penny. And you know, but go ahead, Judy. Let's hear.
Yeah. So, reading through this and going down into the smallest of the weeds, what I find interesting in this provision is discussing, you know, the assumption is that the gaming takes place when the server is located on the reservation. Because that, again, you wanted me to talk class 2, let's talk class 2. And let's talk mobile gaming generally. Because once you have buy-in that the gaming takes place where the server is located on the reservation, then it's not just mobile sports betting that matters. Because once you have cited the gaming event as within the tribe's reservation for the purposes of IGRA, and you're allowing people to place bets off the tribe's reservation, then what's to stop that from other matters? What's to stop that from other mobile platforms? And, you know, Scott can say, yeah, I know what stops that because we lost that case in the Ninth Circuit. But it may be time to take another run at it in a, you know, structured somewhat differently, with this statement by Interior that the location of the server is what matters. I like that part. That's not what they're talking about, but I like that part because near and dear to my heart is the fact that absent an 11th Amendment waiver and absent a very aggressive position at Interior and under procedures, the safety valve is always going to be class 2. And the more lucrative and the more mobile we can make that, that's our leverage against bad compacts, because the state can demand and be reasonably certain of getting revenue share on class 3, but they don't get a penny at class 2. And they know that. And we all know that early days of class 2, well, Seminole bought the Hard Rock franchise with their class 2 operation back before they're even very good.
Whatever happened to that deal?
Sorry?
Whatever happened to that deal?
They got it. Right? They got it.
Very successful.
So as Scott has reminded me, very quietly, there are more tribes that have decided to shuck the compact entirely and go all class 2. Because you can do the math and you can figure out what your revenues are or are going to be from class 2 gaming. And then you don't deduct off any revenue payments to the state. And maybe you keep more, or maybe you keep the same, but you lose the headache. And those options and a viable class 2 industry is what makes the state have to come to the table in a number of places. It certainly is what made the state come to the table in Oklahoma. And in the future, that's going to continue to be true. And to get extremely nerdy in their definition of what is a gaming space, if you're playing on your portable device in your hotel room or on the golf course, does that bring all of that within regulation under IGRA as a gaming space? And I'm not answering that one. It's one of the things that I wrote in the margins as I was reading it.
One of the things I would say, when IGT started their mobile on-premise, they were really one of the only ones. And, as a conference chairman for IGA, I can tell you, I have probably over a half dozen companies now that are doing on-premise mobile. So from this year compared to last year, massive jump. You see Light and Wonder in there. You see Every in there now. You're seeing all these other companies that are looking at on-premise mobile. So
Yeah.
it's a real jump in activity that I had last year. Last year I was like scrambling to make them. Ventos is with their there's an article yesterday about them at Chicken Ranch too. So you're really seeing there's a need and the need is being filled. So I think these rules are very helpful too.
Well, and it's interesting to fold the 2 points together. The Chicken Ranch version of the game, as I understand it, and the version of the game that was just launched by Chickasaws at their WinStar facility.
With Playtech.
Are right. They're class 2. It's sports wagering, but it's structured in a parimutuel bingo type map that they're defending as class 2, and if to Judy's point, tribes may want to be looking to see what they can do, in the mobile market, in the class 2 context. The case that she was referencing that unfortunately was one I was involved in where we lost, was the Desert Rose bingo case, iPay Nation out of the Ninth Circuit. And there, the district court said, well, you're violating IGRA, you lose. But when the Ninth Circuit affirmed, it was on completely different grounds. They didn't agree with the district court that there was somehow language in IGRA that prevented it. It was the language in UIGA, and the argument that the wager has to be lawful at both locations, where it's accepted and where it is made. And because California law didn't allow internet wagers to be made anywhere for any person, then they found Desert Rose bingo to be illegal. But now that these states, since the PASPA was struck down, have authorized all these jurisdictions to where online wagers can be made, there is an argument, I think a very solid one, that there would not be a UIGA violation in those states. So it'll be interesting to see how they flesh that out. It'll also be interesting to see, it's one thing to have on-site geofencing on-site. The Washington tribal compacts, for example, allow for it. But the Washington tribes really to date haven't really embraced it, because they're able to do the brick and mortar, and and the extra revenue really isn't there. But if Chickasaw, if WinStar's working, then and they expand it to the whole of the Chickasaw reservation, that's a much larger footprint. There are tribes that have, especially the large land-based tribes, where if you can take the mobile unit even in a class 2 context and geofence it within the external boundaries of your larger reservation, Puyallup, bring in half the city of Tacoma, so
I've worked on this technology, and where it's going to be valuable is, I don't think you're going to want to be out in the range in the large land-based tribes there, but you are going to want to be on the golf course, and you're going to be in the hotel room and in the restaurant and the other places where maybe you don't have any fixed gaming devices, so that you can be by the pool, you can be all those places, and you keep your player engaged. And you can do that in a very defensible class 2 model that, as the technology advances, becomes very attractive. And so we'll watch Chickasaw and we'll see what they do, but their WinStar is by itself almost a large land-based facility, sorry.
It's
just real quick.
Large.
Yeah.
I saw our good friend Patrick Bergen had a very good quote. Do California tribes now have a greater incentive to pursue procedures rather than conducting a compact through negotiation? It's,
Yeah.
pretty good question.
I don't know if that's a
Depends on the
result of the
governor.
rule
Right.
or by happenstance. I think what really happened there is not the result of the rule being worse than the procedures. The procedures are great. Yeah, it's uh, it's the tactic that California took in the process. They IGRA uses the term mediator for the remedial process. That if a court finds the state's acted in bad faith, then they have 60 days to reach an agreement. If no agreement is reached, then the court appoints a mediator, and each side submits its last best offer to the mediator, and the mediator decides. But it's better. It would be better to frame it or think of it in terms of baseball arbitration. The mediator doesn't have the ability to choose. Well, I like the state's version of testing and the tribe's version of licensing. The mediator has to choose either the state's last best offer and the tribe's best offer. And the tribes in the Chicken Ranch litigation, and then another round of mediator decisions just came out with with all the tribes represented by George Foreman that are very similar. The mediator chose the tribe's version, which was frankly, a Christmas tree that knocks everything out that the tribes found objectionable, because the state provided a compact, that where they insisted on maintaining a lot of those provisions that the Ninth Circuit said, don't belong in compacts. And that's how you ended up with the tribes in the Chicken Ranch and related litigation actually being better off than tribes with states that would strictly apply and be consistent with the new rules.
Victor, what do we got? We got time. I see our friend Francine Dupuis has a question about Montana gaming, which is always an anomaly. I don't know that these compact procedures are going to help the tribes in Montana, where they have a unique set of circumstances. And of course, Montana wields that sovereign immunity,
Well, I think the thing is there, which shows, if you look at with Desert Rose compared to Seminoles, it's really about doing the compact, getting the deal done, having a governor that's amenable to these deals and stuff like that. And if you're still like Montana and even Oklahoma, you're still going to have problems if you're fighting with the governor. If you have an adversarial governor that really doesn't give you a clear path, although it's really amazing to see from the last 25 years, from the Paula Compact and the Paula Machine to today. And I know Judy and I know Scott, you guys were involved in there. I mean, it's been a world of difference. We've made a lot of progress, but the progress in Indian country has always been incremental. And I think that's exactly what this is. It's just another incremental victory for the tribes.
Well, and there has been some incremental improvement just recently in Montana with the new Fort Peck agreement. It's a bit more liberal in terms of the jackpot limits and the number of machines, and it authorizes on reservation sports wagering. But the point, but I think that does serve as a perfect example to where Montana is a state that is clearly out of bounds with IGRA as it relates to the state. For those of you that aren't familiar, is the only true brick and mortar casinos are operated by the tribes. And to Judy's point, some of the more successful ones are class 2 only. But the state has authorized basically slot machines to be operated at small venues. I mean, if you're driving Interstate 90 through Montana, every corner of every interchange, you've got a truck stop type facility that, has a parlor full of these slot machines, and they have limits on the amount of jackpot and what the maximum wager is. And, that's one of those, no-brainers that state, you clearly have to negotiate with the tribes for slot machines, but you have no business imposing your regulatory restrictions on the tribes. And the Fort Peck Compact, I think, is an incremental improvement, but because of 11th Amendment immunity, the Montana tribes may be stuck with getting the best they can. Although I have to caveat that I believe Montana is in the Ninth Circuit, and the Part 291 procedures are valid law within the Ninth Circuit. So the Montana tribes might very well take this rule and try to get the state of Montana to do a U-turn, and if they can't, then go to the department to get procedures.
And
you want to take us out? Yeah, go ahead.
I mean, the procedures also codify what is the technical assistance function.
Mm-hmm.
So with that technical assistance function, and with some clearly pro-tribal elements of this one, the question is always going to be, how are they implemented by the agency? And right now, we've got people who drafted these regulations and mean what they're saying. Mm-hmm. And we don't know where we might be a year from now.
Right.
So that's part of it. Do you mean what you say? Is this going to bind the next folks? Are deemed approved letters going to be aggressive or not? Are rejections going to be aggressive or not? Because an aggressive rejection, then a tribe in Montana can go straight to the procedures process and say, see, this is what they tried to make us do. Now let's get it done right. And that's going to matter.
And Patrick, that answers your question.
Well, I'm good.
I know we're running out of.
Yeah. Go ahead, Scott.
I know we're running out of time, but for anybody that doubts the weight and significance of the technical assistance letter,
right.
It was a letter authored by the Office of Indian Gaming that the Ninth Circuit found very persuasive in it, giving the tribes a slam dunk victory in the Chicken Ranch litigation.
Yeah, thanks for bringing that. Technical assistance, really. I mean, we've asked for so much technical assistance over the year from NIGC, and they rarely will stick their neck out very far. And maybe that's our topic next week, is the pending vacancies at the NIGC.
You know what? Listen, we barely scratched the surface, so I promise you we're coming back, and let's finish this conversation till we really wrap our minds around it, because there's so much here I don't understand, and I'm sure a lot of people are out there like me. So Scott, Judy, thank you so much. This was a phenomenal conversation. Jason, thank you for
no problem. This is super important. I could tell by the level of interest, and people hung on through 5 minutes after. We need to do more of this, and this is where the action is at. But thank you guys, and hope to see you all soon here.
We'll see you next week. We're continuing the conversation, everyone.
Just a preview that Judy and I will be on a panel together with Paula Hart and Larry Roberts on this topic at IGA.
Yeah. We'll be covering this in depth, but you know what? We're going to keep continuing this conversation, because this is a new rule. It's a game changer on many levels. I mean, I think we should all have a real understanding of what's just happened. So again, thanks everyone. We'll see you guys next week.
Take care.